this webinar entitled Selected Contemporary Issues and Trends in Competition Law in Digital Markets, hosted by the Legal 500 in partnership with ELIG Gürkaynak Attorneys at Law. I want to thank everyone in the audience for joining us today for what will be an incredibly insightful discussion headed by some of the leading industry experts. This webinar will last approximately 60 minutes with time for open Q&A. And speaking of which, there's a Q&A function at the bottom where the audience can type their questions at any point throughout the webinar, and panelists will either get back to you at that point or at some point throughout the webinar. Now, without further ado, I'm delighted to hand over to Dr. Gönenç Gürkaynak, founding partner of ELIG Gürkaynak Attorneys at Law, who will be moderating today's session.
Thank you very much. We're in the presence of two great minds of competition law today, and I don't want to take too much of everyone's time with introductions, and there is no brief way of introducing either of these speakers, but I'll give it a quick shot. Judge Diane Wood is the director of American Law Institute in the antitrust law world. You all know how influential the institute is, and she's a former senior circuit judge of the United States Court of Appeals for the Seventh Circuit, and she's a senior lecturer at the University of Chicago Law School. She has very many research interests, and obviously she has had to opine on very many matters relating to the interface between digital markets and competition law so far. Mr. Cecilio Madero is a senior counsel at APCO Worldwide now, and he is the former Deputy Director-General at the European Commission's Directorate-General for Competition, with more than 30 years of service at the European Commission. I don't believe there could be anyone who has done European competition law and not heard of views of Mr. Madero or have been immune from any influence of cases that he may have done. They're both globally extremely well recognized, and as many of you know, the format of this particular event is such that we're setting very experienced minds free in their flow of ideas and thought. We're getting your questions as well. I'm fielding those questions, and we're trying to do a quick job of maximizing some knowledge and sharing it all together in about 45 minutes. So you might be wondering how the preparation of this is happening. It is also kept quite loose so that we don't structure things and we keep the fireside chat format. We've had a half an hour conversation about what we would like to talk about, and now we will get into that chatty mood of conversation. While I will start with, asking a question to Diane and then to Cecilio, then they might be putting questions to each other, or we might be giving comments that are intertwined, also fielding questions, as I've said. So without further ado, I'd like to ask Diane and leave the floor to Diane on whether she believes that in digital markets and enforcement relating to digital markets, especially with the imminent DMA in Europe, the lead is shifting or has shifted to the European Union in terms of enforcement, especially thinking that Lina Khan will need to sell her case to the court in each case, whereas the DMA will provide an ease of enforcement. And that is not to say that the DMA is a superior being. In fact, ease of enforcement may not necessarily always be the optimal enforcement, but there will be swift and quick action. Will this change the trends or further underline the trends that Europe is more and more becoming the locomotive of enforcement in digital, or is it?
It's a very interesting question because Europe has both taken advantage of the ability and it has the ability to create the conditions for competition, to issue regulations, to issue other sorts of affirmative actions, and then companies need to conform their behavior to it. And Europe I can remember many, many years ago when we would have discussions about extraterritorial enforcement, and was the United States pushing its view too much on the rest of the world? And Europe slowly came around to the view that if actions in the world were having an impact on consumers in the European Union, this was a legitimate topic for European concern. I think the US agrees with that. But what happens when there's a difference is that a rational company is simply going to have to comply with the most restrictive restriction because people don't want to be found in violation of the law. In that sense, I think the baton has moved over to Europe, and it is taking the initiative. Institutionally in the United States, as anybody who knows US antitrust law will know, the final authority is actually the US Supreme Court. Our laws are very broad-based. They are common law type laws. And I don't think we'll begin to see special rules for digital markets in particular until the Supreme Court is persuaded that we need them. So I should probably stop there, but I do think it's a very interesting time. And it's actually not just digital markets. I think of the GDPR in the privacy area. The same thing happened there.
Cecilio, a version of the same question, really. First of all, do you believe that the DMA will indeed provide a different type of rhythm of enforcement as compared to the traditional rhythm of enforcement that we have been observing in Europe? And if you do, then what do you think the impact of this will be in differentiating Europe from the other side of the Atlantic? You're on mute.
Right.
There we go.
I was on mute. Now, I was about to say thank you first, Gönenç, for your kind invitations to this webinar. I think that and it's particularly a pleasure for me to share this discussion with a so honorable and well-known and respected judge like Mrs. Wood. And I will try to bring as much as I can some EU or European flavor to this discussion, although I will also at some point go through the Atlantic and try to make some comparisons. But Gönenç, you are asking me the 1 billion or 1,000, I don't know how to define a question, because to try to predict how the DMA, which is now in force, as you have already said, is going to unfold is very challenging. The first question that I always ask myself is how the Commission is going to deal with what I would define as traditional antitrust enforcement, which is, you know, the typical, by the way, the big cases that they are doing, and we have, I say we, because as you said, I've been working for many years for the Commission, and all my career has been in DG competition, and we have always enforced 102, Article 102. But by the way, I should also say that, of course, I do not pretend, and I cannot, and I'm not going to talk on behalf of the Commission because I'm a retired official, so my opinions only are binding on me, and in any respect should be considered as representing one with the other what the Commission might or might not be doing. Having said that, my first question as a former EU official is, or I try to figure out how the Commission is going, the competition in particular, to go for a mix of traditional implementation or implementation of what I define as traditional antitrust enforcement, 101, 102 in particular, and how this is going to, let's say, adapt vis-a-vis the very ambitious and, should I say also, untested waters that the DMA represent. And frankly speaking, I do not pretend to have an answer on everything. And certainly I do not have a crystal glass which allows me, or bowl which allows me to anticipate the future. What I see, and if you have read about the recent decision the Commission has adopted on Apple, is that what I can say at this stage is that certainly between now and the end of Mrs. Vesteyer's mandate, end of this year, end of this commission's mandate, you will see a lot of enforcement on both with both tools. I mean, what I define as traditional antitrust 102 and the DMA. I would add, because I don't want to be longer at this stage, that and I'm well placed to say that this is probably one of the rationales behind the existence and the current enforcement of DMA. The DMA is a response of the European Commission to the slowness and extremely elaborated, at the same time, very long time frames that the European Commission, I think that also the DOJ, the FTC, but I'm talking about the European Commission, had to respect in order to come to an end with, let's say, a high level, very sophisticated, very complicated antitrust investigations under 102, with the risk that we have seen taking place in the past, that when you were able to, when the Commission was able to come to an end with a formal decision, the imposition of remedies, normally behavioral remedies, so from time to time structural remedies, and hefty fines, many times we have seen that the remedy was already not so effective, because in the meantime, because of the time which took the instruction of the case, the market have had tip. And then the DMA is the response of the European Commission, inspired, I would say, by Mrs. Vesteyer, to come on time to big things taking place now, when we are talking. And the first candidate on this respect, there are many others, many, at least several others, is going to be things related to artificial intelligence.
Interesting. On point of artificial intelligence, Diane, where do you see this is going? What will be the particular priorities in artificial intelligence and antitrust as an intersection point? Do you have any favorite topics or anything that is going to attract the attention of enforcers in your view?
Well, I will start by saying artificial intelligence is the topic of the day. Everyone is trying to figure out what to do with it. At the American Law Institute, we are on the verge of launching a project, and there are so many dimensions to it, but I'll pick a few. One is, if you're talking about generative artificial intelligence, which is, I think, what you meant, there's a less troublesome kind that we've all been using for years if we do computer research or anything. But the generative artificial intelligence raises fascinating questions about who exactly is taking certain actions. Can you find that a computer is abusing a dominant position? What does it mean in terms of the ability to share information among competitors? You know, how does that happen? And can you insulate yourself using artificial intelligence? Is it like a common selling agent or like a common buying agent? And how does one deal with, I don't know, mistakes? We've had some amusing situations in the United States just in the litigation context where ChatGPT has gone off and made up facts and has completely misled people. So to the extent that competition law, and particularly unfair competition practices, are the types of things that Section 2 of the Sherman Act or Article 102 in Europe have addressed, we don't know how to assign human responsibility to artificial intelligence. And we're going to need to be thinking of this on our feet very quickly, because it's not coming, it's here. And it's just getting better and better. And so I try to break it down with the ability, you know, traditional areas of law. What kind of responsibility in an injury sort of sense, a tort sense, would you attribute to it? What does it mean about contract formation, or to take Section 1 of the Sherman Act, contracts, agreements, combinations, and restraint of trade? If these are being pushed by artificial intelligence, we might need a whole different way of holding the relevant actors responsible.
Thank you. This also brings me to, and still I'd like to ask this to you, Diane, brings me to what is your personal history of observing the evolution into now we're discussing generative artificial intelligence, and I think at least some of the people attending might really benefit from seeing through your eyes how antitrust has evolved into today's discussion. Obviously, it's a very difficult question to take on, and it will be a caricature of what it really is in your mind, the response. But still, I think it would be very useful for people attending. And I'm seeing very, very influential and extremely experienced figures of competition law also in attendance. I'm seeing Eleanor Fox. I'm seeing Nicholas Sarakis. Yes, very many people attending. And they might be, I can assume they would be smiling in you receiving this question as well, because even with my background, which is only going back to 25 years in competition law, for a good half of it, there was absolutely no discussion of technology in today's sense and competition law interacting in a particularly peculiar way. And you would just use your analogies from any market. You would use dye-stuff cases and your fertilizer cases in technology-related products as well. They were products as products. And today, we're even finding it difficult to attribute liability, as you said. So what is your snapshot of how things have come to this point and what you would expect with that trend of journey?
Sure, that's a very big question, and I will not spend the rest of our hour answering it, I promise you. But it takes me back to a scene in my office when I was at the U.S. Department of Justice. I was the international deputy, but also responsible for legal policy and appellate works at DOJ's Antitrust Division. And a person from the European Union came and was visiting me, and we were having a very nice conversation. And he said, the real task for regulators is to stay ahead of the businesses. And I said to him, I don't think we can do that. I mean, it's a great idea, but I think that inherently the companies, the businesses, the economic actors in the market are always going to be at least a step ahead, if not many steps ahead. And this was at the same time that at the Department of Justice, we had just taken over the Microsoft case from the Federal Trade Commission. And one of the difficult things about that case is precisely what you were talking about, the speed with which the market was evolving for browsers, for stores, for other kinds of things that we were concerned about, way outstripped our ability to go out there and take depositions and to review documents and to do all sorts of things. We did the best we could, and that didn't get resolved. And that round didn't get resolved until years later, probably about 5 years later. Well, I mean, you could take even a computer, and it's maybe good for a doorstop 5 years later, but it's really not keeping up with the time. So the speed of change is something that I remember particularly coming home to us when we were looking at Microsoft, when we were looking at Intel and other kinds of, these major early movers, the companies that have now become the ones that we're concerned about today. And the nature of the product markets, I guess I'll just use a traditional antitrust term, was also changing. As you say, if you're talking about, an international cartel in lysine, the Archer Daniels Midland case, well, we know what lysine is. It's a thing. You use it, or, a vitamin C international cartel. It's a product. People buy it. What is actually the product when you're talking about an internet browser, or you're talking about a chat GPT, a thing that creates generative information, thinking by itself, more or less? that's tricky. And the other thing is that the product markets that we all grew up with before this generation of cases that I think really did begin with the, you could take it all the way back to the IBM and the AT&T cases, but I'll start it with the Microsoft case. The nature of the product itself is hugely different. If you think in terms of the Section 2, Article 102 sort of problem, where there's one firm that's dominant in a product market. Well, that's one form of dominance, but dominance doesn't come in digital markets because of scarcity. You can have an infinite number of copies of digital things. They're not scarce. They're dominant for other reasons. They're dominant because people go out and buy up all their potential competitors, or they're dominant because people are engaged in other sorts of exclusionary practices, preferring one, type of way to compensate people on the Apple Store or something. And so we're needing to dig down to the essence of the competition law rules and figure out what we really care about, because the old models are not helping us.
Thank you very much. Cecilio, in our prep conversations, you were particularly keen on going into the questions quickly as well. I do have a few questions for you too, but I've already received a question that I think is directed at you. This is from Nick Peristerakis, who is a very experienced private practitioner you might know. The question is, do you have any views on the recent action of DG Comp to seek a structural divestiture of Google's ad tech business for abuse of dominance? Do you think that Article 7, as it is currently drafted, gives the EC enough flexibility to seek such a radical remedy, especially when Article 7 was only used once for a divestiture remedy, and even then, this was at the request of the defendant? Could the EC's position be explained by the fact that the DOJ is seeking the exact same remedy before the US courts?
I think that the one who is asking the question knows the answer, but nevertheless, he wants to listen to me too. By the way, I do have an answer. Whether I'm going to be fully transparent about it is something that I still need to reflect or feel. I mean, while I'm talking now.
Would you like to give it a rest and go back to it?
No, but I'm joking. Normally, I'm joking. Normally, I do not escape from questions when I don't want to.
We all know. Yes.
And this is a fair question. Although I do not have all the answers. Now I'm talking seriously. Or in any case, I cannot pretend to answer as I was working for the Commission, because as I said before, I'm not. But very quickly, because I've been particularly interested by, and I fully agree with what Diane said about the previous question. If you allow me to just add something.
Sure.
When she says rightly, or she asks, where is the human? I mean, who is going to be blamed if generative, so-called generative artificial intelligence goes wrong, or because of what it has been done through these generative models, something is wrong? I mean, who is going to be blamed? Or this is one of the questions, very tricky one. Where is the human responsibility on it? If you want me to add to this question others which make still the whole thing more complicated and would call for a longer and probably several seminars in order to deal with this, let's say, set of questions. What happens with, I mean, we all know that generative AI, as everything which is related to AI, has to do with many things, but in particular with data. I mean, I always say in a way which is probably a bit on purpose provocative, that artificial intelligence is particularly, I mean, it's very silly, this intelligence, if you do not provide it with data. Now, the question here is, who are the owners of this data? Just to add complexity to what Diane was already asking. What's going on with copyright and IPR issues related to, what if something goes wrong on the way in which generative AI treats alleged and fully respectful copyright or IPR potential violations. What do we do? And this is a very pertinent question, I repeat, with generative AI that, as Diane said, generates something thinking by itself. I mean, there is no, at the origin, there is no, I mean, this generative AI is generated by artificial intelligence itself, which is very, very impressive and very worrying at the same time. First question, first attempt to respond to it. Knowing as I pretend to know a bit, by the way, I have every respect for her, for Vice President Margrethe Vestager. I can tell you, I still remember her telling me years ago, behind a machine, behind, in that case, artificial intelligence, there is always, I would say, fortunately, a human being capable of being, I mean, a human being who has been, let's say, proposing and moving things forward. So I think that at least the Commission will tend to believe that if something goes wrong with generative artificial intelligence, is going to be for those who are behind or who own these models or this artificial intelligence to respond. Another point that seems to me important and that introduces a sort of geopolitical, and then I will come to the answer, geopolitical element in what we are discussing today. You may, or we may like or dislike it, but there is, how to define it, a perception in Europe, in the European Union, that US tech companies do not contribute enough tangible benefits on tax, employment, research and development, consumer well-being. I could add the things to the list in Europe, and in particular to Europe's businesses. As I said, this is something that might not be accepted, particularly in the US, but this is the perception which exists in Europe. And it happens that all this artificial intelligence nowadays, today, is mostly in the hands of large US companies. And this perception is there. So I think that that's why I said that I think that DMA, under DMA and antitrust enforcement, artificial intelligence might become a core field of, let's say, implementation of these rules. But I don't want to add more about this. I'm just saying that there is this perception in Europe that US large big tech companies not only are already dominant in many respects and in many markets, but also that with this artificial intelligence, this dominance, which is already very, very obvious, could be entrenched in such a way that it's going to be very difficult to really compete and to recreate a sort of level playing field. Now, from this perspective, I will try just to add something on the question which has been asked to me. First of all, I don't know what Mrs. Vestager and the Commission, not only her and DG Competition, but the college as such, I mean, the European Commission, will decide on this specific case, Google, that has been raised. I have heard, like you and others, that it is not excluded that so-called structural remedy could be imposed or at least considered by the European Commission. As you said in the question, this is not something that it is excluded either coming from the DOJ on a similar investigation. I have the feeling that under Article 7, which has also been mentioned in the question, the Commission, by the way, it does it, I would say, almost daily, particularly on merger investigation. But I think that for an antitrust case like the one that you have mentioned, the possibility for the Commission to adopt a structural remedy is more than just a possibility. It could happen. Whether this is going to be the case or not, I don't know. I'm not in the secret, and I'm not running this from inside the Commission. But certainly it is a possibility.
Thank you. Diane, on the point of extraterritorial impact and extraterritorial enforcement, do you think in the digital sphere we're coming too close to leading to national authorities changing the product so much, or interfering with the design and architecture of the product so much that this leads inevitably to extraterritorial enforcement? Or would you believe that if a certain authority's enforcement's direct outcome is that kind of a revision on what the product is, this is inevitable for that enforcement agency, and this is not an intended result, but one that the companies will have to live with. Is there an argument in there, do you think, or do you think this is just a byproduct of what the product is?
Well, I think when we try to think about extraterritorial enforcement in the digital world, the first thing I think of is the practicality and the economics of it. It is possible. We see this with China, for example, or we see this with Russia. It's possible to build kind of a digital wall around your country and have a certain regime within it. I'm not saying it isn't a little leaky, because it probably is, but it's relatively effective. And so you could do that. Now, I would think both us in the United States and the people in Europe would have to have an awfully good reason to impose that kind of tremendous economic inefficiency on their companies. It's much better if we can find a way that will allow us to operate more harmoniously. Now, the thing that I saw in the question that you've been talking about, the last part of it was, could the EC's position be explained by the fact that the DOJ is seeking the exact same remedy? So that takes me back again to the Microsoft case.
Yep.
What we did in the Microsoft case had not been done before, but as you know, the Commission was looking at Microsoft for very much the same alleged violations of the competition rules as the DOJ was. And there are, of course, national confidentiality rules about the way investigations go forward. But what we did is we each, so DOJ and the Commission, went to Microsoft and we said, would you be willing to waive your confidentiality rights so that we can do this as a harmonious, integrated whole? And personally speaking, I don't know what anybody else thought, but personally speaking, I was a little surprised, but Microsoft said yes. They wanted to facilitate a single solution, because for them, the worst possible world would have been to try to sell their operating systems in one configuration in the United States or perhaps North America, and sell it in a different configuration in Europe. This has led, we've done this before, and it doesn't work very well. We did it with CDs, we've done it with a variety of things I can think of. And so I know nothing about what the EC or DOJ is doing, I assure you, it's been longer than I care to think since I was there. But it would not be unprecedented if, on a confidential basis, the EC or the Commission and the DOJ are trying to work together in this structural thing. By the way, I just want to make a quick point about remedies. Structural remedies are very rare in the United States as well. They are considered a very drastic step to take. But unlike Europe, the United States antitrust laws don't provide for Section 2 of the Sherman Act to be enforced with civil fines. So you can bring a criminal action, which hasn't been done since 1969, under Section 2. But we are more or less stuck with behavioral remedies or structural remedies, but they just don't get used. And so the behavioral remedies are what you're left with. it has led to a very careful and I would say modest use of Section 2 in the US. And I think what may be happening now is digital markets are causing all sorts of concerns, as we may be seeing a renaissance of Section 2 that has come about because there's economic thinking that varies from, say, the traditional Chicago school of the 1980s and 1990s. So I think there's some fascinating theoretical change that's happening in the United States, and it may lead to enforcement changes.
Thank you very much. Cecilio, so you've, as they say, you've seen both sides of the table, but you've been with the Commission for 30 years, which means that not only did you keep the pulse of the agency, but that kind of a time duration means you were the pulse of the agency for such a long time. And it really is a very interesting question, at least the answer I'm really interested in, that once you started working with companies that are trying to make their points to enforcement agencies or bureaucracy at large, have you had any moments of, aha, so this is something that I thought, or we at large thought was largely scaremongering. There's nothing there. They keep on running these arguments, but what is the big deal? And then once you switched to the other side of the table, you have diagnosed that it is genuine, or that you were devoting a lot of time and energy on certain arguments, and you just started believing now that you have switched that it is hot air and there's not that much of a big deal in there. So any points of disappointment or any eureka moments in your new career now?
Well, I don't know if this is a new career. In any case, it is true that I'm not. By the way, I've been working for the Commission, and this doesn't make me very young, by the way, 34 years. So, and always in DG competition. So I'm an extremely bad example of mobility within the European Commission, because I have always been working in the Competition Directorate-General, because I like the material, I mean, the matter, the subject matter, and also, but this is very personal, because every time I was about to leave, I was offered a promotion and then I decided to stay. But this is the past. Now, before I go back to this, again, Diane said something that I subscribe entirely, which has to do with the fact during these 34 years working for the Commission, we never tried to engage in extraterritorial implementation of our rules for the sake of being more intelligent than others or more ambitious. I mean, extraterritoriality is something which, in principle, can be a sort of unintended result of a specific decision, but not something that you can do on purpose, because as you know very well, Gönenç, we have no jurisdiction before the EAA. So, but it's true that from time to time you can impose, in particular to large companies, remedies which would make almost unavoidable for this company to extend the order that they get from a specific authority beyond its jurisdiction, because otherwise it's a nightmare to, as Diane said, to apply to different types of products or to different softwares for something which is very similar, regardless on what side of the Atlantic you are. So enough for extraterritoriality. Also, I agree with her that structural remedies are really exceptional. It's something that only exceptionally the Commission would consider, in particular on large antitrust investigation. But as I said before, it is part of our battery of rules that we can implement. I mean, the Commission can implement. And I don't think that, again, I don't want to appear having insider information that I do not have, because I'm not anymore in the Commission. But I would recommend to those who are listening to this seminar that they follow closely and with a lot of attention what this commission, DG Competition, my former colleagues, and in particular Executive Vice President Vestager will do between now and the end of her mandate, because I know it's public information that she has a full package of pending cases to be solved. And knowing as I know her, a clever, honest, and at the same time very ambitious lady, I'm pretty sure that she will do her best to handle to whoever is going to be the new commissioner as from early next year, a full package of cases already decided. Now, coming to your question, well, first of all, while I was working for the Commission, I never had the impression that we were always fully right. Although, yeah, when you believe that what you are doing is relevant, you tend to believe that until proven the contrary, you are doing something which is right, but you need to be ready to accept that companies or judges, frequently enough judges, tell you the opposite. Certainly the Commission, while I was there, and in particular me, I'm not talking about the institution, I have made a lot of mistakes. I think that we have also adopted decisions which are, I shouldn't say that because I'm part of it, but some of the decisions that I have in mind are milestones which explain why the Commission has in my opinion, a leading role as an antitrust enforcer and now as a regulator in this domain of digital domains or on this, let's say, new economy. Having said that, with my new activity, which I'm senior advisor for a consultancy firm, what I try to do is to help the clients of APCO, which is my company, my current employer, where I work, as I said, as senior advisor, senior counselor. I try to help them to navigate the waters that from time to time are very shaky. I mean, I try to help them when they need to negotiate or they need to try to find a modus operandi, a solution with antitrust enforcers, and in particular with European national authorities or the European Commission. But you know, after 34 years working for the Commission, nobody can expect me, and you won't see me helping anyone to cheat with the European Commission. It goes against my culture.
Yeah, I think it would be also
to help them. Yes.
Oh, go ahead.
No, to help companies to understand and try to minimize, if possible, negative outcomes coming from the European Commission is something I'm happy to do. And by the way, I'm trying to help, but with full respect to my former house.
Sure, sure. It would be an interesting note, I think, that first time I met Cecilio was exactly 20 years ago. The Microsoft case was new, well, relatively new-ish in the EU. And Cecilio and Jean Ubi and Nick Panasevich and obviously Mario Monti, there was an enforcement against Microsoft, and I used to practice in the US, and I was then practicing in Brussels so that I helped out with the Microsoft case. And I'm remembering that even in those years, in 2003, we were using, as defense counsel, we were using a lot of brick and mortar examples, and that there wasn't the same culture of specialist, digital argumentation. The reason why I asked Cecilio, for the benefit of the viewers, whether he has seen that certain arguments are scaremongering or that they were actually quite powerful and they were discounted, is because there are so many new concepts that are employed in the digital sphere, tipping, or ecosystems, the impact on ecosystems. And now more and more people, I think, are feeling that either there should be more deference to these and people should look into this, or that some people are feeling this is exaggerated and actually there isn't much to it. Which brings me to another adjacent point, and that's the last topic I wanted to cover with both of the speakers, and that is the concept of innovation at large, and innovation and competition law. Particularly in the merger control sphere, we're seeing so much happening. And this is happening particularly in pharma, but also in digital, as innovation theories of harm in merger control. Last, we have seen Microsoft Activision, but if we were to throw the concept of innovation in there as a ancillary part of digital and liberate ourselves a little bit to discuss it not only in the digital sphere, but Illumina Grails and Dow DuPonts and all of them, the concept of innovation and theories of harm belonging only to innovation, particularly in the merger control field. I'd like to hear first Diane and then Cecilio as to whether they're feeling there is something to it and innovation theories of harm are articulable, and this is now something that can be anticipated by merging parties beforehand, or do they feel that while once it is articulated, it is palpable, it's very difficult to estimate, and there will be these surprise events in transactions course of journey. So Diane, over to you on innovation theories of harm and merger control and what you're observing in the recent trends of enforcement.
Sure. Well, actually, let me take it back to 1995 when the merger guidelines in the United States and actually the intellectual property guidelines, both of them, were revised. My colleague, Rich Gilbert, who was at that time the economic deputy in the antitrust division, really pioneered putting the innovation competition theory into those guidelines. It was a central theory of Rich's, which he then continued developing for many years thereafter. He's probably still doing it, but I haven't talked to him recently. But understanding the particular role that innovation plays in the competitive process was something, it's hard to put your hands around it, but what I think it captures is the problem of certain kinds of merger analysis is that it tends to be too static. You know, you're looking at the market now, but innovation analysis forces you to ask what it's going to be like tomorrow and the next day and the next day. Pharma, you mentioned, which is a great example of an area where that's where the competition is. That's where they're investing their money. They're going through all of these elaborate processes. They'll tell you that most, new devices, new drugs, new therapies don't work out, so they have to figure out how to finance the innovation. That is where the competition comes from. So I don't think it's easy. It's not like saying, here are 2 kilograms of innovation and that's what we're going to charge you for it. But you have to have that in there because it's intangible ideas, it's things that might not even be visible that you're going to see in the future. Innovation in software, innovation in operating systems, innovation in so many things that will be the drivers of competition. So if we don't pay attention to innovation competition, I think we're going to be missing the boat.
Cecilio, same question, but obviously also I'm wondering if there could be a fallacy in all of this as well, in the sense that when, for example, when we're looking at pharma markets, obviously there is a process in a particular product hitting the shelves, and you have for the US, you have the FDA approval process, so you have phase 1, phase 2, phase 3, and all that, which means you have a pipeline. And when you have a pipeline, it is a tad easier to talk about innovation theories of harm that may happen in the future. And when you see that a lot of the debate on innovation theories of harm is happening in the pharma markets, one cannot help but wonder if it is because there is more visibility into the product hitting the shelves that we're enforcing in this field. And yet in the other markets, this also exists. It's just not as transparent to the enforcement agencies, so there is less enforcement. Could there be a fallacy there? Or do you think there is a meaningful distribution of innovation-related worries in the competition law realm at the moment?
Well, when you were asking to Diane before and now to me this question, I was already coming to the conclusion that this is the typical seminar, as far as I'm concerned, very interesting because of the question that you were asking, which would call for much more time in order to be able to just articulate a bit the answers. But I will try to do my best with the limited time we have. Well, first of all, I would like to, I will start with your question, the last part of your question. On so-called, you talk about pharma, I would talk about life science industries. I think that the Commission is more and more incorporating, I'm talking about the European Commission, innovation as something which is part of the, in particular, merger analysis of any notification that they get and that they consider deserves full attention, and in particular when they engage in second phases and then more or less tricky and complicated and very elaborated decisions. But I think that pharma is one of the candidates to this type of innovation theory of harm, but digital markets are also very much subject to this type of analysis. I would say that there is no a specific treatment of a specific sector with a sort of very sophisticated or very, well, not sophisticated, very special interpretation of what innovation is. Having said that, I have the feeling that, allow me to say a couple of things which would explain a bit from where I come myself. Innovation per se is good. I think that we all agree. And if we are facing if antitrust enforcers need to face cases where innovation is part of their analysis, I have the feeling, or I hope that they will come to a conclusion that if the innovation is genuinely, it's really innovation, it has to be at least respected or taken seriously. I mean, respected in the sense that it should not be, it shouldn't be, how to say that, prohibited from the one who brings innovation to the market, not to take advantage and benefit from this innovation simply because it is not an European company. What I'm saying with this is that when faced with genuine innovation, it should be treated with care and, should I say, respect, regardless from where it comes. The question is, what if these innovative elements of this innovation coming from let's talk, for example, about big tech, facilitate, it's not innovation which is the problem, but the fact that this innovation could be used in a way which makes more difficult for competitors to challenge the dominant position or the market power that the company in question could have in the market, which is being examined by that case, the European Commission or the DOJ or the FTC. So my point is, innovation per se should be respected coming from wherever it comes. If the innovation is used in a way which facilitates entrenched dominant positions or abusive market power, then we are in a different scenario. But I feel a bit, how to say that, worried when I see some European politicians, I wouldn't say the European Commission, but some European politicians trying to discriminate because, oh, this is not coming from Europe. Sorry, if it is, I mean, if in the cloud market, the big guys are not Europeans, still you need to live with them because you need the cloud for your own European companies. I think that you understand what I mean. Now, antitrust rules are not, I think that we all agree on both sides of the Atlantic. I think that antitrust rules are not, how to define them, dead bodies, something that cannot change. On the contrary, I think that when now you rightly refer to new concepts, like, for example, ecosystem, I mean, series of harm, which are going to examine if the specific behavior or situation that you are analyzing takes place in a specific ecosystem. Well, first of all, we should agree on what we mean by ecosystem. And if you want me to be provocative, from time to time, I'm asking myself when I hear talking about ecosystems, whether the idea is to define in a different way what dominance means and implies, or if it is a way of trying to avoid to deal with dominance. I think that you understand what I mean. Because it is obvious that, I mean, the way in which traditional dominance is defined under 102 is, as you know, can be very exigent. If you use this ecosystem theory harm, hopefully you need also to demonstrate that the company to which you are, I mean, the company you are examining really respond to this set of, let's say, dominant position that you consider could be the open door for the subsequent abuse that you try to define. So I don't think the antitrust rules are trying to adapt to a new, to new concepts, to new situations, to a digital economy in which, as Diane said before, large language models or generative artificial intelligence are developments which were unknown, I would say, a year ago, and which bring us to new untested waters. I have the feeling, and with this I conclude, that precisely because all this is very new, and because we need, I'm coming back to what we were saying at the beginning of this seminar, it is even from time to time difficult to define who is the responsible for these new developments and for something that might be wrong or could be considered wrong under antitrust rules. I have the feeling that on top of the effort that regulators on both sides, again, FTC, DOJ, the Commission, do in order to adapt the rules to new realities, is going to be for judges in both sides of the Atlantic to state the law, which is what in a democratic European Union or in a democratic country like US you would expect happening. So what I mean by that is that many of these new cases which are now being decided or might be coming soon to the attention of major antitrust authorities will end up in litigation in different courts. And it's going to be for judges to tell us who is right on this type of... Consider, for example, Article 22 of the merger regulation, and this idea of the Commission to use Article 22 in a way which de facto might make very difficult for large companies to buy new or nascent companies. But this gives room for another seminar. But to what extent an antitrust enforcer has the right to systematically make almost impossible for a big guy to buy a nascent company, because the idea is to avoid any possible potential future abuse by taking advantage of the technology or the IPRs or the know-how that this nascent company might have. And because of the use that this large company buying the little one the use that it might do of this new technology. I mean, again, to what extent we have the right, I mean, when I say we, I'm talking about antitrust enforcers have the right to avoid this type of transactions. I think that this is for another seminar.
Yeah. No, it's very interesting. Thank you very much. Last intervention by Diane. I don't have any questions, but Cecilio has given certainly a lot of food for thought. And I just wanted to check before wrapping it up if you have any last observations, remarks to make about what he has said, and then I'll be thanking both of you.
Well, certainly, thank you. And I will be brief, but what I think I'm hearing, especially as we confront new levels of competition, is that as markets evolve, the plane on which competition is taking place itself changes. And so I would give you the example in the United States of what we would now probably call financial services. There was a time that we would have had banks in one market, and we would have had investment companies in another market. We might have had credit unions in another market, and on and on. But as the industries evolved, it became clear that it was really just a financial services market. And I thought of this in conjunction with your reference to the ecosystems, because these are kind of big interdependent systems where different functions intersect with each other. They're interconnected technologically and otherwise. And I won't say that it harks back to the Keiretsu of Japan during World War II, but they are much more all-purpose, and they call for an understanding of how competition operates at that level. And they also, I had a thought in terms of the innovation point, as Cecilio was speaking. He was defining very usefully a lot of ways in which maybe innovation is implicated. And I thought sometimes it's a little easier to think of how it can be harmed, and so innovation can be harmed, for example, if you shut off the outlets that this new entrant into the market, this innovator, might hope to use. Maybe they can't get on Amazon and use the store, or Google, or so this whole idea of exclusionary practices in today's world, I think, deserves a very careful look. Now, I think in Europe, under the abuse of dominance provisions of the treaties, it's always been there, but it's been a sort of a second-rate theory for a while in the United States. And when I say a while, I mean 30 years. But I think that's the way innovation has been harmed. That's the way these new markets are stifled from being brought forward, to the harm of consumers and to the harm of the people who would like to serve those markets. So I think, again, as I said before, some really interesting reformulation of our theory, or at least more careful formulation of our theories, is going to be necessary. I do have to say, I've been a judge for the last 29 years. And so don't be too hard on the judges. We get these cases. I've written about extraterritorial antitrust. I've written about, exclusionary acts. I've written about cartels. I've written about all sorts of things. And it's a fascinating opportunity to really crystallize what you think the law means. So I'll stop there.
Yeah. Thank you so very much, Diane, Cecilio. I didn't understand how an hour has passed, but it did. And this was certainly promising to be a very, very interesting session, and it certainly was. We've touched upon a lot of topics. As Cecilio has said, we could have devoted a whole seminar to each of these topics, which was not very fair to either of you, but then you were very kind in catering the jump from one topic to the other. Thank you very, very much. And I'm hoping to see you either at ABA Spring or with a certain other occasion, face-to-face, in person. Take good care, and thank you very much for everyone joining in. I have seen that at some point in time, it has gone up to about 110 people actively following, and with people coming in and going out. we have generally had a very good attendance. And this time, people registering were about 300 and I think 17 people. So there was good interest, and I am very grateful for all the content that you were so kindly sharing with us.
Thank you for everything you did. It's a great pleasure to be with Cecilio.
Thank you.
And for me, Judge, it's always an honor to share a panel with someone with your high reputation. I have never been a judge, but believe me, I've been confronted to many in Luxembourg, and it is not always easy, believe me. Many thanks.
Thank you very much.
Thank you so much to our wonderful speakers and to everyone in the audience. Thanks again. Bye.
Bye-bye.
Bye-bye.